Hi, this is Colby, and welcome to another edition of Hold My Briefcase, where I talk to you about legal issues and legal topics so that you can have some weapon to take with you into your next battle. Don't be taken advantage of because you don't have the knowledge. Learn it here. It's like having a lawyer in your ear. So today I'm going to be talking about something that is a little confusing to most people, is confusing to me, and it's even more confusing because the Texas legislature and the Texas Supreme Court is constantly changing the law here. Now, remember, the Texas Supreme Court is also an elected body, just like the Texas legislature. And I have to tell you that some of the highest paid lobbyists are in the insurance company. So there has been a move, I don't think anybody can deny, to make the ability to recover for legal damages much more conservative. So with that in mind, I wanted to talk to you about damage elements in Texas: lost wages, loss of earning capacity, and future medical care. Now, if you've been hurt you obviously would probably have some medical bills and worrying about your future. And the question most people have is, what kind of compensation can I get for my injuries? And Texas law allows victims to recover economic damages. These are the losses that have a specific financial cost. You're allowed to recover economic damages and non-economic damages. First one I'm going to talk about is non-economic damages. These damages are of three kinds, right? There's three types of economic damages because you can put a financial number to them. First, there's lost wages, money you would have earned if you hadn't been injured, right? You got a job, 9 to 5, you missed Monday and Tuesday. How much money would you have made? There. Remember, damages are to reimburse you for your loss and harms, your harms and losses. How were you harmed? What did you lose? Let's put a monetary value to that and hand it to you as damages. Next is a is an interesting one. It's called a loss of earning capacity. And that's a reduction in your ability to earn money in the future. This one's a little more complicated, and the example I use is this when I'm explaining this to my clients. Imagine you're a trash truck, trash man, right? And you lose your arm in an incident. So you're now one armed. The requirements for being a trash man is to be able to hold your weight up with one arm and be able to pick a trash can up. So you're medically restricted from being able to complete your job. Your job would have gotten you, say, $100,000 a year, and now, because of your lost arm, the the job, the highest level income job that you can obtain right now is $60,000 a year. So the delta is $40,000. Over the life of your employment, how much money did you lose because you had a loss of your earning capacity? What was your ability to earn money in the future? Now, notice this is different from lost wages, and that lost wages are, your what is specific. You had a wage, it's specific. Loss of earning capacity is a little more speculative. Not speculative, it requires different proof, which I'm going to talk to you about. Future medical care. This one's pretty easy to understand. What is the cost of the surgeries or the future medical care is going to be required for you to be made whole? Medical care you're going to need down the road. Now, each of these damage claims have specific legal requirements, which means you must prove your losses with evidence, right? You can't just come in and say, oh, well, I think. No, you need evidence. You also may need expert testimony to support certain claims, particularly when you're arguing for long-term care and financial losses. Prove your losses with evidence, right? You can't just come in and say, oh, well, I think. No, you need evidence. You also may need expert testimony to support certain claims, particularly when you're arguing for long-term care and financial losses. Now, I'm here to try to explain really quickly kind of what you need to know if you're going to be making these claims. And for example, in Texas, you must, there's the lost wages. And lost wages, as I said, represent income that you were unable to earn while recovering from your injuries. Now, unlike other types of damages, lost wages are based on actual measurable losses. Then you can prove them just with the documents. So how do you prove them? You must prove that you were employed before the accident. You must prove that you missed work because of the injury. Usually you have a doctor's note tells you you can't work, and you lost a specific amount of money. You can't guess. And there, because Texas law requires reasonable certainty when you're proving lost wages, which means that you must provide clear evidence that shows how much money you lost. Now, this is usually required pay stub, a W-2, documents showing how much you were earning before the accident. We have taken employer statements, signed pieces of paper, a letter from your employer confirming how much work you missed and what your hourly rate was. Your medical records would have a doctor's note in there stating that your injury prevented you from working. You can also get your work schedules that show what you would have been working had you been working. Now, what you do for the lost wages, pretty easy. You take your hourly, you take the amount of time you mix, you multiply them together, and that's your claim. All right. You can present this to the insurance company directly. If you're a self-employed employee where you earn commissions, an economic expert may be needed to calculate your lost earnings because they're a little more speculative in nature. So where you're like, well, if I would have been working, I would have made this much money is a different argument than I had a job. Here's my paycheck. Here's how much time I missed. So there's a little difference in the law because remember the Texas rules of evidence and Texas law. In fact, most rules of evidence, including the federal rules, require that there be certain proof. But not only that, when the jury is getting outside of their stuff that they should know as a lay person, which basically means an average person, then you need an expert to help them understand, right? Um, yeah, a layperson isn't going to understand how much money, for example, an independent contractor would have made if dealing with a publishing business, but they are going to be able to understand that you were supposed to be paid for this money amount of work and you were paid this many hours. Pretty easy, no expert to explain. Let's move on. Loss of economic earning capacity. Look, I already explained this with the example with the driver who's the trash can man. If your injury prevents you from doing the same work or forces you to take a lower paying job, you may be entitled to compensation that takes care of and reimburses you for all the losses that you may have in the future, right? But how do you prove the loss of earning capacity? Well, you must show that you were earning money before the injury, that the injury permanently affects your ability to earn. You have to prove the amount of money you were likely to lose over time. And the Texas law requires expert testimony to prove this kind of damage claim. Courts will not allow a jury to speculate about what your future financial losses would be. You must provide concrete evidence, right? And so what that requires usually is a medical expert testimony. A doctor must state that your injury permanently limits your ability to work. For example, you are not able to bend over. You are not able to stoop. You are not able to stand for long periods of time. Those restrictions are then taken by a vocational expert who takes those restrictions, determines which jobs you can and can't do, and issues an vocational expert report, which evaluates your work skills and determines which job you still can do.